So the Supreme Court recently granted review to the next big Second Amendment case, and it once again deals with state concealed carry restrictions and laws that were passed by some states in direct defiance to what the Supreme Court said in the prior 6-3 ruling in a case called New York State Rifle and Pistol Association versus Bruin. And now the Trump DOJ has submitted their brief, an amicus brief, in support of striking down these types of concealed carry restrictions. This is great news, and it's great to see that the Trump administration once again is jumping into this case in support of this two-way effort. Now, this all comes in a case that was granted review by the Supreme Court. It's heading to oral arguments in January, and this case is called Woolford versus Lopez. This case is huge for everyone in states like New York, New Jersey, California, Hawaii, Maryland, and others who are currently living under these types of concealed carry laws, which were passed in direct defiance to what happened in Bruin. The Hawaii Woolford case sought emergency Supreme Court intervention, which surprisingly was in fact granted by the Supreme Court. This challenge revolves around a preliminary injunction and the Ninth Circuit finding that Hawaii's catch-all public property ban is permissible under the Second Amendment. Now, recently, to the surprise of many, the Trump DOJ and AG Bondi actually stepped up in support of this challenge, and they called these type of state bans a violation of the Second Amendment. They also called for the Supreme Court to grant review to this case, even though it was on an emergency basis, and that may have ultimately also helped this case to get Supreme Court review. So I want to, in some ways, give the Trump administration and AG Bondi, their flowers in this case, because I do think that their initial amicus brief and request when this was seeking review ultimately led this case to being granted review by the Supreme Court. And still, once again, they're jumping in support of this case by filing a new amicus brief calling for the Supreme Court to strike down these types of concealed carry laws. Now, if you're not aware, the Woolford case is a challenge to Hawaii's new laws on concealed carry, which were passed in direct response to Bruin. Now, this law, like others in other states, tried to add more restrictions to concealed carry and create this default rule where individuals can carry their firearms, can carry their handguns concealed on private property only if the owner of that property actually gives you express consent, only if they tell you expressly that you can concealed carry there, or they put out a sign that says, yes, concealed carry is allowed at this location. Now, plaintiffs, along with 2A organizations, sued the state of Hawaii to strike down this law, and they actually received a preliminary injunction temporarily blocking this law in Hawaii. Now, Hawaii decided to appeal that. It went up to the Ninth Circuit, and the Ninth Circuit, on review, reviewed this Hawaii case and the California concealed carry ban, which is very similar, and they ruled in favor of the state of Hawaii. And after that, the plaintiffs then tried to get the Ninth Circuit en banc panel to review this case. However, the Ninth Circuit en banc panel did not want to review this case, and they denied the case. And that led the plaintiff here to then seek emergency Supreme Court intervention. And now the Supreme Court has in fact granted review to this case, and oral arguments are currently set to happen in this challenge on January 20th. Now, the question that the Supreme Court will answer in this case is whether the Ninth Circuit erred in holding in direct conflict with the Second Circuit that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission to the handgun carrier. Now, that means that the Supreme Court will directly address the catch-all property bans that were put in place in direct defiance to what happened in Bruin. And once again, the Trump DOJ submitted a new amicus brief in support of this case, heading into oral arguments. And once again, they argue that ultimately, the Supreme Court should rule in a way that strikes down these catch-all public property bans. The first thing argued in this new brief by the Trump DOJ is that Hawaii's affirmative consent rule violated the Second Amendment because it was designed purely, in fact, to suppress concealed carry within the state. It was not, with the underlying goal of protecting property rights or anything like that. The true purpose was simply to frustrate 2A rights. They argue that Hawaii and these other states already have protection for property rights through traditional trespass laws and things like that. And property owners could already forbid firearms simply by posting a sign that said simply something like "no guns allowed." But this default ban that was created in states like Hawaii is not necessarily about protecting property rights. That's not the true goal. It's actually to frustrate 2A rights. The Trump DOJ argues that these laws are all about making public carry practically impossible in direct defiance to what the Supreme Court said in Bruin. They point out in the brief that this law and its structure amounts to almost a near complete ban on concealed carry. every business in the state of Hawaii and some of these other states would be covered under this language, and that includes their parking lots, sidewalks, and it covers a whole suite of businesses like restaurants that serve alcohol, gas stations, pretty much anywhere that you would go that is technically private property but is open to the public, and the public often goes there. This restriction makes it so that lawful concealed carry owners cannot engage in their common daily activities while concealed carrying. Even though they have a lawful concealed carry permit, they simply just can't go to these locations because of the way that the law is written. They also point out that the people who helped draft this law actually admitted that very few business owners would actually opt in to this law and post signs that said something like concealed carry is allowed at this location. That means that this law was not actually intended to protect property rights, but instead simply to expand gun-free zones to almost everywhere within a state. Finally, the Trump DOJ points out in their brief that the historical tradition put forward by the state of Hawaii does not support this law at all. Simply put, this is a modern invention created in direct response to Bruin with the goal of actual defiance and banning concealed carry. The DOJ shows that the historical presumption has always been that individuals could conceal carry arms at any location, almost every location, unless the owner affirmatively actually banned them by putting a sign out or telling the patrons who come in that no, you can't carry a firearm at this location. This law in Hawaii, like the other states, turns that historical tradition completely on its head and changes the historical tradition from what it traditionally was, what everybody accepted and knew it was, to something completely new that was actually drafted in direct response to Bruin. And based on that, the Trump DOJ asked for the Supreme Court to rule in a way that strikes down this type of catch-all property ban that was passed in states like Hawaii. So briefs are now being submitted to the Supreme Court for their oral arguments in January, and soon Hawaii will also file their response. But it's still great to see that the Trump DOJ is jumping into this case once again in support of striking down this concealed carry ban. Like I mentioned, this case will be very big for states like Hawaii, but other states as well, like California, New York, New Jersey, Maryland, and others. And all these states that passed new laws after Bruin, when Bruin struck down may issue licensing schemes, these states decided that no, they don't want to move to shall issue. They'll just kind of move to this pseudo shall issue scheme, but really place a ton of restrictions still on concealed carry and make your permit almost useless because you can't go anywhere lawfully with that permit. There's also a possibility that the Trump DOJ will even request permission to participate in these oral arguments, and that's something that we will keep our eyes on, and we've seen actually the Trump DOJ do. We've seen Harmy Dillon actually participate in a 2A case dealing with Illinois' rifle bans in the 7th Circuit, so that's also something we're going to be watching for to see, do they actually ask to participate in those oral arguments that are going to take place in January. So again, a huge case dealing with the Second Amendment, the next big 2A case that's really going to outline, how does the Bruin analysis actually operate, once again in the concealed carry case, but also it could impact other 2A cases going forward based on what the Supreme Court says. But again, it's a good thing that you have the Trump DOJ in this case on our side fighting against these 2A restrictions. So as it develops more, as we get more information, I will let you guys know. If you like this video, and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. You can also check out one of the 2 videos here on the screen that the YouTube algorithm thinks that you'll find helpful. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.